So I have an important update in the nationwide block against the ATF and their pistol brace rule. So let's talk about what is happening. So like I mentioned in the intro, in this video, I have an important update in the ATF pistol brace cases. The ATF recently submitted their opening briefs and they submitted their arguments to the Fifth Circuit Court of Appeals. The ATF now argues that the decisions down below should completely be thrown out, and essentially they're arguing that the NFA's tax requirement means that these lawsuits are improper and that they should have never been filed and allowed to move forward. Now the plaintiffs in this case have responded in the Fifth Circuit, and they're arguing that the Fifth Circuit should essentially reject all those ATF arguments. Now you may recall that the ATF recently decided to roll the dice and appeal the pistol brace cases up to the Fifth Circuit Court of Appeals. Those appeals included the Mock versus Garland case, which is the FPC case, and then also another case, which is the Brito case, and that dealt with a nationwide preliminary injunction as well. A lot of those cases that were originally in front of the Fifth Circuit were decisions on preliminary injunctions, which are simply more temporary forms of relief. However, the Fifth Circuit recently decided at the consolidated hearing and consolidated review of those cases to moot all of those appeals because those dealt with preliminary injunctions. Now, the only case moving forward right now at the Fifth Circuit level is the Mock versus Garland case because that deals with a final merits decision from Judge O'Connor. Originally in Mock, the Fifth Circuit Court of Appeals found that the plaintiffs were in fact likely to succeed on the merits of their arguments, which were brought against the ATF that the ATF had violated the APA, which is the Administrative Procedures Act. They then sent the case back down to Judge O'Connor, who then issued a preliminary injunction finding that the ATF did violate the APA because the final rule was not a logical outgrowth from the proposed rule that the ATF had put in place. Judge O'Connor then issued a final merits decision in Mock, striking down the entire rule nationwide. In his decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule, and it is relatively straightforward that the final rule was not a logical outgrowth from the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. Now, that decision from Judge O'Connor was a huge win, and now it sets the stage for the Fifth Circuit to review the final merits of this issue to determine whether or not the ATF overstepped with their pistol brace rule, trying to make all braced pistols actually SBRs and then subject them to the NFA's requirements, the registration, the taxation requirements, and all of those things that come along with having an SBR. In response to that new decision, the ATF first sought a stay from Judge O'Connor, which was denied by Judge O'Connor, and then they appealed up to the Fifth Circuit. But at that time, they also did not seek a stay from the Fifth Circuit, so they have conceded that the nationwide vacatur of the rule would remain in place at least until the Fifth Circuit rules on the merits of this case. Now, in the ATF's opening brief to the Fifth Circuit, they argue that three main things need to be reviewed. First, whether the plaintiffs are entitled to relief on their logical outgrowth claim. Second, whether the rule is arbitrary and capricious. And third, whether the district court's universal vacatur was impermissibly overbroad. The ATF argues that the notice of proposed rulemaking provided sufficient notice to permit interested parties to comment. Although the rule heeded commenters' concerns, by declining to adopt the Notice of Proposed Rulemaking specific proposals, the NPRM previewed the rule's reliance on objective evidence of intent and specific probative evidence identified in the rule. What the ATF is arguing here is that Judge O'Connor came to the wrong conclusion, even though the Fifth Circuit had said prior that this rule did violate the logical outgrowth test. They also argue that the Fifth Circuit should abandon their prior determination and rule in a new way that this was a logical outgrowth from the proposed rule to the final rule. The ATF then goes on to argue that the final rule did not violate that test. They argue that the proposed rule's report card system had themes and objectives and certain identifiers in it that then carried over into the final rule. They claim that those concepts mean that there is enough consistency between the two rules from the proposed rule to the final rule to pass the APA's logical outgrowth test. Now, if you're not aware what happened here, what they're saying is that with the report card system that initially was in the proposed rule, which had a point system where you would look at characteristics and add up points, and if it had reached a certain threshold of points, well, then it was deemed to be an SBR. The ATF scrapped that after the proposed rule and then had more just kind of vague, overbroad statements of objectives, a 6-factor test that you would then use to determine if something was an SBR. They say that there were enough themes and concepts in both of the proposed rule and the final rule to pass this test. Finally, the ATF argues that at the very least, the Fifth Circuit should remand the case back down to Judge O'Connor because they believe that Judge O'Connor could not issue this universal vacatur of the rule. The ATF argues that Judge O'Connor exceeded his authority and he should have issued a more limited relief that potentially only protected the named plaintiffs. To make this claim, the ATF walks out their new favorite argument, which is the Tax Anti-Injunction Act, also known as the AIA. They claim that the AIA bars this type of relief because it would stop the payment of a required tax under the NFA. The ATF states in their brief that in all events, the district court erred in universally vacating the rule. Instead, any proper relief had to be tailored in two ways. First, proper relief cannot restrain the ATF from applying the rule in the context of assessing and collecting the NFA's tax. They go on to state that the Tax Anti-Injunction Act, which generally prohibits suits for the purpose of restraining the assessment or collection of any tax, bars this universal vacatur entered by the district court. Now, if you've been following the channel for a while, you will know that the ATF kind of first rolled out the AIA requirement when it came to the NFA tax requirement. They rolled that out first in the Made in Texas suppressor freedom case when that was an appeal up to the Fifth Circuit. The ATF tried to use that to dismiss that case. Now, ultimately, that case was dismissed based on standing issues, but they tried to use the AIA and the NFA's tax requirement in the Texas suppressor case, and now they're trying to use it in the pistol brace case. Now, in response to the NFA tax argument, the plaintiffs have filed their response brief, and they state that the agencies argue that vacatur of the final rule is barred by the AIA. Because the NFA imposes a $200 tax on covered firearms, the theory goes that this suit is covered by the AIA since plaintiffs' challenge will prevent the ATF from collecting the NFA's taxes on SBRs covered by the final rule. This argument is circular in that it assumes that the agencies are correct that the arms at issue are properly covered under the NFA and therefore subject to its tax requirement. As the district court concluded, however, the firearms that would have been regulated by the final rule are outside the NFA's taxation regime from the very beginning. They go on to point out that, moreover, the AIA does not reach all disputes that are tangentially actually related to taxes. So here they're pointing out that the AIA does not bar all lawsuits because maybe they're loosely in some ways tied to a tax requirement. Instead, the AIA actually applies when the primary purpose and the primary relief that is sought in the lawsuit is related to a tax issue. Here, the NFA tax requirement really is just a secondary issue. The primary issue in this lawsuit is whether the ATF had the authority to classify braced pistols as SBRs under the statutory text, and then also whether or not they engaged in a correct rulemaking process under the APA. So the NFA tax issue is becoming more of a forefront battle in this lawsuit, primarily because the ATF is trying to use it to wiggle their way out of this lawsuit to have this case thrown out and potentially have the nationwide vacatur also removed. So very interesting developments in this case, but in general, there still is good news that the nationwide vacatur of the brace rule is still in place. That applies to everyone nationwide. So the brace rule is currently still blocked. This appeal will move forward at the Fifth Circuit level. And I don't think that the ATF is going to find much favor at the Fifth Circuit level. The Fifth Circuit has ruled against the ATF multiple times on this issue and other ATF overreach cases as well. So I don't think that they're going to win this. A lot of their arguments are weak and they're trying everything in their power to try to win this case, but I don't think it's going to play out in the ATF's favor. So as things develop, I will let you guys know. Also, if you like this video and you like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.